It's time for a little comedy, a little content, and a lot of conversation. It's the Geno Jones Show, exclusively right here on YouTube. Now here's your host, Geno Jones.
Hello, it's showtime. Good afternoon, good evening, good morning, whatever time it is, wherever you may be watching all over the world. It is time for the Geno Jones Show. That's me. I'm Geno Jones. We do it live right here, Monday through Friday, 6:30 p.m. Eastern Time, right around 6:30, 5:30 in Chicago, 3:30 in Los Angeles. And it is, I'm going to jump right into the monologue. I've got my all-star panel, and I'm excited. It's going to join me, part two of our conversation from yesterday. Akila Carson, my all-star contributor, and attorney Paul Ellis, who just gave just really some outstanding legal perspective yesterday. If you didn't see yesterday's episode, check it out. And as always, Keela, she brings the heat. So go back and after this, go back and watch yesterday's episode, because actually we almost in real time, you know, we actually got the verdict probably about, let's see here, about an hour and a half. Yeah, about an hour and a half before I went live. So it was real. It was raw and real. The emotion was raw and real. So let's talk about the day after a jury of 12 people found Derek Chauvin guilty on all three counts of murder and manslaughter, second-degree murder, third-degree murder, second-degree manslaughter. So June, I believe is June 16th or June 8th? I think June 18th. So in about 8 weeks, and I just heard the news, so he will be given his sentence on June 18th. He is in a maximum security prison in the state of Minnesota, like on 24-hour watch. Saw video of the cell. He's like solitary confinement. He can only leave his cell for like 1 hour a day to go exercise and do whatever. So now, because there were so many emotions, it was real emotional for me. I think I mentioned in real time yesterday when the actual verdict happened. I just screamed. Hey, yes, yeah. In real time. As a matter of fact, even my dog, my schnauzer, Teddy, was cheering along with me, because I did not expect guilty on all three counts. I was so afraid of a hung jury. A hung jury, in case you don't know, is where if just one person out of 12, for whatever reason, didn't see murder. Because what we now know, we knew it on May 25th of last year, on Memorial Day. What we saw was the murder of a human being by another one. We knew that. You had a 9-year-old child, a 17-year-old teenager who videotaped it, who knew that was murder. But all it would have taken was one sympathizer on that jury, for whatever reason, to say, no, I don't think it was murder. I think, because he had a bad heart and he had some fentanyl in the system. Even more, no, if it wasn't that much, or maybe the carbon monoxide. The car wasn't running, but maybe it was still carbon monoxide in the air, or maybe the sun was aligned with the moon and Aquarius was in the 10th house, or whatever the hell. Just because everything killed George Floyd, according to the defense attorneys. And I get it. That's their job, to defend their client. But it just got so ridiculous. It was obvious bullshit. And I believe that hurt the defense. Because these jurors are like, okay, wait a minute. So you want me to believe all this BS that you're telling me? That this heart condition was so lethal, and the amount of fentanyl in his system was so lethal, and the amount of carbon monoxide, which was actually 2%, which is the same amount of carbon monoxide that's in your body and my body right now as I speak to you. All these other factors somehow, but at the same time, he was going to have the superhuman strength. And if Derek Chauvin would have taken his knee off of his neck, he would have risen up like like a phoenix from the ashes, like the Incredible Hulk, like Superman coming back to life, and somehow been this lethal threat to Derek Chauvin's punk ass. We're supposed to believe that. And the jury was supposed to believe that, and they was like, no, my brother, no, we are not falling for the banana in the tailpipe. No, like the prosecutor said, trust your eyes and use common sense. Prosecuting attorney Jerry Richardson, man, he had a drop the mic moment. The very last words that jury heard was that the defense attorneys would have you believe that George Floyd died because his heart was too big. No, George Floyd died because Derek Chauvin's heart was too small. Rest my case. The rest is history. But around that same time yesterday, when some millions of people all over not just in America, all over the world, tens of millions of people, just some joy, relief, could just exhale and breathe. There were so many of us that just did not think that we would see accountability. No, it was not justice. You can't get justice. You know, and when Attorney Ellis joins us, I'm sure he'll explain this to you. You know, in the law, you can't get justice without full restoration. Whatever was taken from a person to get justice, they have to get a full restoration of what they lost. Justice has to be full and restorative. So we can't bring George Floyd back to life. Little Gianna, she won't get to hug her daddy. She can't put her arms around her daddy anymore. He can't take her to the park. He can't teach her how to swim or how to ride a bike or teach her how to drive a car or how to drive a manual stick shift in a car. He can't he can't be her escort if she runs for homecoming princess or queen. He won't be able to be there when she comes down the stairs and she's got her prom dress on. He won't be there to cheer at her graduation from high school or college. He won't be able to take her to college on that very first day with all her boxes and clothes and move her into her dorm or student housing. He won't be able to walk her down the aisle one day and walk her to the altar and give away his daughter to the man who wants to marry. She won't have that experience. So Gianna, she could never get justice, but we did get accountability. But in that same moment, literally in that same moment, in Columbus, Ohio, 16-year-old, a young lady, 16-year-old Ma'Khia Bryant was shot 4 times and killed by a Columbus police officer, Columbus, Ohio cop. Now, the body cam video of the police officer is out, and I'll paraphrase it. We're going to bring Keela in just 1 second. So the young lady, according to all the sources and all the various reports that we've seen, the young lady who was shot and killed 4 times in the chest, she actually called the police because she was in fear. There were some older girls. Apparently, she's in a foster home. She finds out these older girls are coming to her house to attack her and beats her up. So she gets a hold of a knife. It wasn't like some big kitchen butcher knife. Relatively, small to medium-sized knife. So the police officer drives up. There's a fight. Folks are fighting. I see one guy kicking some girl. So we see the video where Ma'Khia Bryant is fighting. And then there's a young lady. They kind of fall back up on a car. And it looks like Ma'Khia is going to try to stab her with the knife. Now, keep in mind, when the officer got out of the car, he didn't grab his taser. He didn't go to the trunk of his car and get a shotgun that shoots beanbags. Because police officers, whether you know it or not, police officers have several methods of non-lethal force to use. Police officers, many police departments, In their trunk, they have a shotgun that will shoot not bullets, but like a beanbag. And then they have a taser. So this officer didn't, you could argue, he didn't have time to go to his trunk, but he had a taser on. He didn't. His first instinct was not to grab his taser. His first instinct was to grab his gun, to grab his Glock. And then, while they're tussling, it looks like Micaiah is stabbing toward this young lady without really trying to diffuse the situation verbally with other officers on the scene. He shoots her in the chest 4 times. Now, I want to put this in context, because some say, well, because some of the, I believe, people from the police department there in Columbus, Ohio, say, well, he was trying to save the life of another young black teenager. Okay. 17-year-old Kyle Rittenhouse. This was a white teenager. Kenosha, Wisconsin, last summer. Kyle Rittenhouse, big, MAGA supporter, self-deputized, left Illinois, crossed the border, 40, 50 miles to Kenosha, Wisconsin, shot and killed 2 people. Two people who were protesting the shooting of Jacob Blake in Kenosha, Wisconsin. So Kyle Rittenhouse shoots and kills two white men. This is a 17-year-old white teen. He wounds a third one. Then he begins to walk down the middle of the street in Kenosha, Wisconsin, with an AR-15 strapped over his shoulder, strutting like a peacock, just prancing like a horse in the Kentucky Derby, proud, chest stuck out, head up, no fear. He walks past several police officers on foot, in their cars, with an AR-15 on his back, and people are yelling, hey, he just shot and killed 2 people. The police didn't even stop. The police are having a conversation like this 17-year-old kid has been on the force for 30 years. He was not even arrested on the scene when you had eyewitnesses that was telling the police he just shot and killed 2 people and shot a third person. They didn't shoot him, and he's got an AR-15. They didn't feel threatened that a kid walking down the street with a semi-automatic weapon on his back, and he got his hand on it like this, and they didn't feel threatened. There's something wrong with that. So, what do we need to do? I'm going to repeat this and I'm going to bring Keela on, and if Paul can join us, then he will. I'm going to beat this drum until it happens. You can say that I'm being repetitive, that I'm doing all of it, damn it. Closed mouth don't get fed, and the squeaky wheel gets the oil. Number 1, President Biden, Vice President Harris, Senator Joe Manchin, who I got his phone number. I called his office. I'm gonna need you to stop cock blocking. I'm gonna need you to get out the way. Either you are for equity, you are for accountability for rogue police officers, for murder, for police officers who use excessive force and murder, or you're not. Are you about protecting the lives of black or brown people, Senator Joe Manchin, or you're not? Now, I get it that your state is 93% white, only 3% of your state, you have black people. This dude's a millionaire, so you don't feel that you're not accountable. You probably really don't give a damn, honestly, because how do I know? How can I say that? I can say that by your actions or your inaction. So, repeal qualified immunity. Nationwide, there are 18,000 different police departments in America, 18,000. So you need a law that will cover all 18,000. And qualified immunity. What was qualified immunity? So what does that mean, qualified immunity? All right. And how do we get it? First of all, by passing the George Floyd Justice in Policing Act. The George Floyd Justice in Policing Act. That's the name of it's the bill. It's already passed the House of Representatives, the United States House of Representatives. It's in the Senate. Let's vote on it. Let's pass it. The George Floyd Justice in Policing Act. Repeal qualified immunity. That means that you can sue police officers personally to seize their pension, their financial assets, bank accounts, property, stocks, liquidate all of their assets, their financial assets, or liquidate their assets, get the money, and give it to the victim or the victim's family of the people who were victims of excessive force or worse. In the case of Derek Chauvin, the murder of George Floyd. Like I said, if I can't appeal to your sense of humanity and morality, I need you to run me that pension. All that money, I need you to run me that. Oh, house is paid for. I need you to run me that deed. Oh, the car's paid for. I need you to run me that title. Oh, some money over here. Oh, you got another account. Oh, what's that? That's tuition for your son or daughter. Sorry, partner. They're gonna have to get a bank loan. I'm gonna need you to run me that money in that account. What else? What you got? Secret account? I need you to run me all the money you got. I need you to run me that deed to the house, the title to that car. If I can't appeal to your sense of humanity, your sense of morality, I can dig in your pockets and I can get your attention. Because unfortunately, the truth is I bring on Keela Carson. The one thing that I have learned in 5 decades of on this planet is that people in general, especially people with money and power, they worship money and power more than they worship God. And that's just fact. Let's bring on half of my all-star panel. Hopefully Paula can join us tonight. Ladies and gentlemen, once again, we're doing a double shot back to back. She needs no introduction. Regular contributor to the Geno Jones Show. Ladies and gentlemen, as my girl Tina Turner wrote a song, it's simply the best. She's simply the best contributor in the media. Miss Keela Carson. Keela Carson.
Hey, Geno.
What's
How
happening?
are you?
I'm good. What's happening? Okay.
Pretty good.
I'm on one. You know, I'm on one every night. But,
you said a mouthful,
yeah.
So we'll dial it back in layers.
No, wait.
So we're going first.
Listen, take the floor. Don't dial nothing back. Be key because you bring the heat. So you got the floor. Where do you want to start?
Okay, so I think I want to start with the Columbus shooting.
Okay. Ma'Khia Bryant.
Ma'Khia Bryant.
Mm-hmm. 16.
So I don't know if we're taking a stance here, but after reading through all of the information, because I haven't seen the video, so I want to be transparent yet.
Okay.
But having read through the story from a couple of, media outlets, I can't really say for certain that the police were at fault, because you can't compare what happened in Columbus to what happened with the young man with the rifle, at the Black Lives Matter rally where he committed murder. You can't compare any two police active situations together. You can't do it.
Well, let me just explain to you.
Oh, wait, Geno.
Okay. Well, no, but I want to go back.
You're in the heat of the moment. So I just wanted to say that I would have to take a back seat on passing any judgment, because the officers are in an active situation where an individual is trying or attempting to stab someone. Now, according to the information that I understand, she was the person that called.
Yes.
But when you're an officer that comes to the scene, you don't know that. You don't know who is who. All you see is an individual with a knife trying to stab somebody. So you don't know if that's Ma'Khia or or some other person. And that's not how you make decisions. You don't, as an officer, you can't say, oh, that's the one who called, so let me not shoot her. Let me shoot it. You're just trying to save a life. So now you go ahead.
So let me push back on that. Okay.
Okay,
In
push,
theory,
push.
no, listen. In theory, I hear what you're saying, but I'm telling you what my eyes have witnessed. Because this whole thing about a threat is just different circumstances. So okay, yes, he comes to the scene. Boom. All right. First of all, you see, and he's not the only officer. You see kids, you see teenagers. You don't see a gun. Now, yes, the girl she got a knife in her hand, but why was his first instinct, Keela? His first instinct.
Because
hold on. I don't know. Let me just say
listen.
this. His first instinct, not his second, not his third. His first instinct was to grab a gun. Not to grab his taser, not to use less than lethal force, which I know for a fact. I'm telling you, I've had conversations with several people in law enforcement that have been in law enforcement who are in management positions, who've trained other officers. So yes, you can say that I don't know what I'm talking about. I'm just ranting. You can say what you want to say, but I'm telling you that I come to this position having done some research, having talked to people that have been in that situation. I'm telling you, I saw a video of a white dude dragging a police officer. He was holding on to like a truck. And
okay, but Geno, we're talking about this situation. And that's what I want people to be careful of. You cannot use that situation for this situation and this situation for that situation. I am saying, if I'm an officer and I pull up, I don't know if you're a teenager, I don't know if you're a kid.
You can see it. He can see this as a kid.
Okay, well, I'm just okay. So I'm talking generalities, because generally when you pull up somewhere and I have teenagers in my life that look like grown people. So I'm just saying you have to wait and because this is where we get into trouble. We cannot, under the umbrella of Black Lives Matter, we can't say that now police can't go out and do their job.
Oh, you can do your job without.
Sometimes, Geno, you have to do what you have to do. Now, I'm not saying that was the right situation. I am saying I don't know enough about the situation to pass judgment.
Well, I can pass judgment because I saw the video.
Absolutely, because you're you.
Right. And it's not just that. Not just that.
But Keela's not passing any judgment.
No. I don't want you to. Wait. No. And that's fair. I wouldn't. I just wanted to get your take. I'm not asking you, but what I am challenging is the notion, and I get it, and I can appreciate. But see, because here's the problem, Key. You are looking at it from a very practical, I would say professional in terms of how officers are trained. But I'm telling you what I witnessed, and I'm telling you that black bodies are policed differently than white bodies.
That might be true.
Well, it is true. It ain't a might. It's a definite. It's fact. You got
that might be true, Geno, but that doesn't mean that every shooting is about that. So I'm saying I need to see what is investigated. I need to understand more about this situation. I need to understand the officer and what the frame of mind was, what was going on at the scene. Because these are split-second decisions that have to be made.
Yeah. Well, actually, it wasn't a split second. It was 10 seconds, first of all.
Well, okay. Geno.
Right. And then when he got out, like I said, his first instinct, Keela, when he got out the car, was not to even, think, let me use the first instinct.
How do you use a taser when two people are going after each other? I mean, a taser is about a direct shot. I can get this thing. A taser,
he had as much a direct shot as he did using that 9mm.
No, Geno.
Yes, he did. I saw the video.
Okay, I get it.
I saw the video. I get you. That's all I'm saying. So you can't tell me that somehow that the taser was going, be like squiggling and wiggling back and forth somehow.
We'll ask our Esquire.
Tasers are going in a straight line, just like a bullet. Now, it didn't travel at the same velocity that a bullet does.
No, okay, so
and my
let's bring Paul in and let Paul, because we're not going to see eye to eye on this.
No, it's not. We're not supposed to see. We're just having a conversation. Right. It's not about. I don't want you. I'm not. Listen. I'm not asking anybody to see eye to eye, but I'm telling you what my eyes saw and what my eyes have seen over decades. There's black bodies are policed differently. Black and brown bodies are policed differently than white bodies. As a matter of fact, you don't have to take my word for it. There's data behind it. There's data that has existed. Academics have done studies for decades. Police departments, they know this. They got the damn data. That black bodies are policed differently. Black bodies are viewed as a threat in a way that, in general, white bodies are not. Period. There's data behind it. There's anecdotal evidence behind it. So my thing is that the instincts are always to shoot to kill first. But when I've seen officers in threat,
but numerically more white people are killed by police each year than
only
blacks.
Because
now,
white,
and I know that
black people make up roughly 14 to 15% of the population, as opposed to white people making up over 60%.
I get it, but you don't want to
proportionately.
But I'm putting on my debate hat.
Let's have that conversation.
Someone could come in and say, but by sheer numbers, more white people are killed by police.
And then I will tell them that black people are killed at 3 times the rate of white people. So you can play with the math any way you want to. At the end of the day, if white people in America were being shot at 3 times the rate of black people, this wouldn't be a conversation. You're talking about police reform or reforming public safety, it would change. So that is my biggest rub. And I got some answers, I believe, for one of that. And one of the answers, then we're going to bring on Paul. Paul, thank you. And then we'll kind of go back to some questions we had yesterday about the Chauvin trial. I would require police officers to live in the community that they police.
Yeah, well, we've had that before here in Detroit. And,
it didn't work.
People have arguments about that, but
it's
a valid point. Yeah, all city officials in some places they require. Others say no. It's about what the community wants. We've had that issue in the Metro Detroit area a number of times.
I guarantee you, if a bunch of black officers were in suburban Detroit, Grosse Pointe is one of the wealthiest suburbs in America. Or there's certain wealthy suburbs in Pittsburgh we're about to bring Paul on. Or here in Charleston, if you had a bunch of black officers in Sullivan's Island or Mount Pleasant, and white teenagers and white kids were being murdered, I guarantee you, there would be a change. You would have a new mayor and a new police chief and a new city council, and there would be new policies implemented to where, we've got to change. If we have to disband the police union, whatever policy we have to enact to stop this, it would happen. So damn it, I'm tired of excuses. I don't want anybody else to be killed. I don't want any white kid to be killed. I want black kids and innocent, unarmed black people to stop being murdered. Let's bring P's on camera, ladies and gentlemen. One of the top attorneys repping the University of Pitt there, Mr. Paul Ellis Jr., R.I.P. P knows me, Key know me too. So, all right, we'll let you bring in the legal expert. Let's go back because Keely, you had a question.
Yes,
we want to go back to the Derek Chauvin verdict. Why don't you go first, and then I got something I want to ask you too.
So my question to Paul is now, we were looking at 75 years, but because we know that this is a situation where, since all of the charges relate to the same crime, I believe this is how it goes. He will only be facing 40 years because that's the larger number, I guess, with
I heard
the
the same
second
thing.
degree
Yeah.
murder, right? So he's only looking at 40 years, even though we see 75, but it's going to run concurrent.
Well, now let's see. Oh, go ahead. Well, you going?
Okay, so
Let's
I
ask
wanted
about,
Paul to explain to us, what is the judge going to go through? What is the process for her to determine how many of those 40 years Chauvin will serve?
and Key, because we talked about it, Paul. This term, this aggravated, this legal term you could explain.
Yes.
This aggravated circumstances that the judge is a man actually, that he
Oh, yeah, I'm
he
sorry.
has a he has, because apparently they asked Chauvin's attorneys and Derek Chauvin if he wanted the jury to make a decision about these aggravated conditions, the fact that he murdered George Floyd in front of a 9-year-old and teenagers. Could you explain in layman's terms what that means? And are these sentences, they're concurrent, which means they all serve together as opposed to consecutive? Could you just clear that up for us, man? And thank you for joining us.
Yeah, thanks, Geno and Key. I'm glad I could make it with you guys today. You definitely have you guys you've covered the entire spectrum of policing in the last few minutes. Every $64,000 question, every major issue, just about. You guys are having a loaded discussion.
Yeah.
Let me. I guess I'll start with sentencing first. So Key, you asked about a maximum of 40 years.
Right.
So whenever you hear a maximum like that, it means just that, right? The absolute most that person can serve. If he actually did 40 years, they'd have to release him from jail at that point. So there are things that the most common thing that weighs into how much time a person serves is, first of all, whether they're state or federal, because unlike the state system, federal, and this is a state case, right. but just for discussion, they don't have a parole system in the federal system like they do at the state level.
Okay.
So whenever you hear a minimum and a maximum in a state case, that means that the person has to serve the minimum no matter what before they're eligible for parole. So if you hear 20 to 40, 10 to 20, they're doing at least 10 or 20. Mm-hmm. That'll be the minimum. So there's this case called Blakey, and what it does is it impugns, it obligates the court, the fact finder, the judge in this case, whether it's a jury trial or not, to weigh either mitigating or aggravating circumstances surrounding a case, right? Some cases are very straightforward, right? But if you, and I'll use a really, basic example, right? If you are driving drunk and somebody gets hurt, that's a pretty straightforward case, right? You ingested too much alcohol, you operated a major machine, and somebody got hurt. Now, if somebody that got hurt is a child because you were doing 80 miles an hour in a 25 miles an hour school zone, that's an aggravating circumstance.
Gotcha.
It's an elevated risk. It shocks the conscience of the court, right? But if you were driving drunk and it was part of a 3-car collision and there's some blame to go around, and the first thing you did was jump out and try to administer CPR, and you were the one that called 911, and things like that, those could be mitigating circumstances.
Okay.
So every case has distinctions like that. In a case like this, it's kind of foreseeable what each side is going to argue, because there's a lot of, contrary to popular opinion, there's a lot of straightforward arguments with regard to the Derek Chauvin case, right? The attorneys tried to muddy the waters, and the defense attorney was doing their job. But the fact of the matter is that You have there were children watching this whole scene. They will be traumatized by it. You had a gentleman who lost his life unnecessarily in one of the most depraved and callous ways that a person can lose their life. And um, it's one thing to subdue a suspect with force, but the obligation to cease force at a reasonable amount of time, that's a legal obligation. It's not a matter of discretion. Mm-hmm. So the fact that if I'm the prosecutor on the case, an aggravated circumstance that I'm going to point out right off the bat is the fact that Chauvin continued to kneel on George Floyd after he's no longer moving, after there's no pulse, after there's no threat.
Yep.
And to the point where even the medics had to encourage the officer to get off of him. And you've heard comments about the fact that Chauvin had an indifferent look on his face.
Yeah.
His responses to George Floyd, the cavalier, indifferent attitude. Those are all aggravated circumstances. The fact that he had his hand in his pocket, which reflects,
please,
which is a physical manifestation that he's not in it, that he doesn't consider himself to be in any danger, and it's just very cavalier. That's an aggravating circumstance all day long. So the judge, now what happened in this case was that Derek Chauvin, he could have had the jury decide whether or not there were mitigating or aggravating circumstances, but he actually waived that right in court and gave that authority to the judge to decide whether or not there were mitigating or aggravating circumstances. So the judge is going to hear arguments from both attorneys and decide whether or not there should be some years taken off or some years added on based on those circumstances.
So could he actually add more years to the 40 with the aggravated circumstances or not?
No, he cannot add to the 40.
Okay.
What he can do is add to, there's going to be a recommendation. Minnesota has its own sentencing guidelines. And so what they have to do is they have to weigh, that's why you have pre-sentence reports. Okay. The pre-sentence report is designed to, it depends, both sides will file a pre-sentence report. Derek Chauvin's attorneys are going to file a pre-sentencing report that's going to attempt to humanize him. He's a family man. He was a police officer. He doesn't have a prior record score. He's a good man. A Catholic upbringing, whatever. I'm just making up things that, So they'll humanize him, and then from a factual standpoint, and then from a legal standpoint, they will cite the sentencing guidelines. And let's just say, for example, that it calls for 20 to 40, the absence of a prior record score, which I believe Chauvin has a prior record score of 0. So once they agree on the sentencing guidelines, then the judge will have the authority as to whether or not to add years onto that minimum based on the mitigating or aggravating factors.
Yep.
So I got 2 questions, P. I had one, but I got 2. So the one that just popped in my head while you were answering Keela's question. Now that Derek Chauvin is a convicted murderer, does he lose because he's no longer a police officer? So doesn't he lose the qualified immunity protections legally that he had? And does that mean that, because here's my question. Okay, I know that there was a settlement, financial settlement, civil settlement with the city of Minneapolis for $27 million. But if I'm Darnella Frazier's parents, that young lady is a hero, and the parents of her 9-year-old cousin, and there was another teenager, and maybe the adults, can they file a suit citing, you can help me, you the attorney, what would you, emotional distress, trauma, because especially those children are traumatized for life. So is there any civil legal recourse that because we know that the Floyd family can't because they've already agreed to a settlement. But is he in any more civil liability jeopardy, Derek Chauvin? And then I'll ask you the second question after you answer this one.
Right. Yeah. The problem with qualified immunity is that it applies to the set of circumstances that was in existence when the facts that gave rise to it in the first place transpired. That's the problem with qualified immunity. So because that 9-year-old girl witnessed these events at a time when he was a police officer, that would pose an uphill battle for them in terms of a civil lawsuit.
Wait, so you say uphill battle, but you didn't say that they couldn't sue. You're just saying you don't think that they would win the civil suit?
Well, I think it would be, I try to stay away from absolutes in the legal system because of what we were talking about yesterday in terms of juries being unpredictable.
Right.
This is not a usual case. But the biggest problem, and keep in mind, it's a civil case, so she'd have the burden of proof. She doesn't have legal standing, right, to bring a case. Let me rephrase that. The only legal standing that she would have would be one that's based on, something like emotional distress. But she'd have to prove that. She'd have to go to court with medical records and psychiatric records and things like that, and show that his actions, and then of course the other side, you can already anticipate what they're going to say. Assumption of the risk. She could have walked away. Happenstance. She was there. Things like that. So, it would, and then of course you have to deal with the qualified immunity issue. So. I think that and every state has a different set of laws. So if she were to hire an attorney to look at that angle, they'd have to take a long, hard look at Minnesota's specific laws relating to the normal causes of action that would arise in a case like that, which would be intentional infliction of emotional distress, and in any common law case that dealt with psychological impacts. So it either way it'd be an uphill battle.
Okay.
But yes, he has lost qualified immunity now because you can only have it while you're a police officer.
So the second question is really a prediction on my part. And I want to get your take on it. Keel and I talked about it after the show, post show. We always have a post show conversation.
Sure.
I got a feeling that at least one of the 3 officers that's about to face trial, because those are going to be 3 separate trials. They're not being tried together. They're being tried as individuals, if I'm correct, right, Pete?
That's correct.
I got a feeling after seeing Mr. Chauvin being taken off in handcuffs with his hands behind his back, I wouldn't be surprised if one, if not 2 or all 3 of those police officers have a conversation with their attorney and be like, Attorney Ellis, yo, man, can we plea out?
Make a deal. Let's make a deal.
Listen, I'll sing like Ronald Isley in the versus battle versus Earth, Wind, and Fire and Steve Harvey. I'd sing like Philip Bailey singing Reasons live. What do you want to know? I'm snitching on everybody. So what do you think? Do you think I'm crazy? Am I off base with that? What do you think the chances of somebody copping a plea after seeing that? Oh shit, man, he guilty on all 3 counts? Yo, I'm not trying to play craps with my life here. I'm about to step away from the table. Yo, can we plead out? So give me your take.
Yeah, well, those officers have to make some serious decisions, because the decision on whether or not to plea will lie ultimately with them, right? The attorney cannot make the decision for them. each officer's attorney can come to that officer and say, this is what's potentially on the table. This is the discussion I've had with the assistant district attorney. So they can have those discussions, and the attorney can make a recommendation. They can have a discussion about the pros and cons. But ultimately, Geno, it's a personal decision, and the last say rests with the client. Now, I will say that I think the prosecution has the upper hand with regard to those three officers, because, and it's not. There's a couple of reasons. The most obvious is because the momentum of the verdict.
Yes.
Right, as you just pointed out. But and another reason is because they're not. They do not have to rely upon those officers. There was some discussion early on about the prosecutors relying on the testimony of those three officers to get Chauvin, the big fish.
Right.
But instead, they went after Chauvin first. They put together an effective strategy. They got a conviction, and so now these officers, they're on their own.
Yeah.
They have to fight their own battle. So the prosecution has an upper hand in that respect, in addition to the momentum of the Chauvin verdict. And the smartest thing that the officers have done so far is to sever their cases. I would have done the exact same thing if I was any one of them. You file a motion to sever, and because it is easier to defend when you are part of when you're part of a situation where it's all lumped together like that, right? I mean, they were all three of them were there, right?
All four of them actually, all four, yeah.
Right.
I mean, well, yeah, exactly. Some people are going to look at that and say they shouldn't even be allowed to sever, right? It's not like they were different incidents.
Good point.
But you can do that, particularly if the judge grants it. It's up to the judge to grant a motion. The bottom line is that it's even though they're part of the same situation, they are still three different human beings. They have different track records. They have different histories. They have different tenures on the police department. Some of them encouraged Chauvin to get off of George Floyd, and others didn't. Right. So I would have severed. Any one of those officers has a reasonable basis upon which to sever their case from the other, and just try to enhance their chances as best as possible for a plea deal.
So you said
their arguments are going to be what you would expect them to be. There'll be some arguments that we don't know about, but there'll be some familiar ones. And yes, the prosecution is going to have to give some favorable weight to the officer that said, well, yeah, do we want to get up off of, things like that. They have no choice but to give that some favorable weight. So that's going to weigh in their favor.
So you were saying there's different levels of culpability. I think that's my mic's, Pete, you getting feedback on you. Maybe if you can cut me down. Okay. I was wondering, because I just had a feeling like somebody is going to try to, but you and I had a conversation also last night, and you didn't mention it here. So I want you to mention this for the audience and for Keela, because you said the person that has the final say is the defendant. But actually, you told me last night, actually, the defendant doesn't have the final say. Now, correct me if I'm right. Didn't you say the judge has the discretion, even if the prosecution and the defense come to an agreement on a plea agreement, that the judge has the final discretion to accept or honor this plea agreement or not? Now, did I understand you correctly last night?
Yes, you did. Yes, you did. So the defendant has the final say as to whether or not to accept a plea deal from the prosecution. But whenever both of them agree, the prosecutor and the defendant, through the defendant's attorney, whenever both of them agree, they have to propose that plea agreement to the judge, and the judge may or may not accept it. You may not. You don't hear about it happening too often, but there's plenty of cases where where a proposed plea agreement is put before a judge and the judge doesn't accept it. And there's a lot of reasons for that, right? Sometimes the attorneys know each other or the prosecutor knows the defendant and they come up with this agreement that's ridiculously lenient and ridiculously disproportionate to the underlying conduct.
Okay.
You know what I mean? What do you mean this guy's getting one? You reach a plea agreement where this guy's getting 1 year probation. And he murdered somebody. This is unacceptable to me. Right. So the judge looks at the plea agreement, determines whether or not it's fair, whether it makes sense, and then he or she decides whether or not to accept the plea agreement that's proposed by the defendant and the prosecutor. If the judge agrees, they sign off on it, and it becomes a court order. It becomes law, and and any other legal rights that stem beyond that, like an appellate right or something like that, then that it kicks in after a certain point, 20 days, 30 days, something like that.
Wow.
So I have a question. Geno, are you
No,
done?
go ahead. No, I'm done because I know we're running short on time.
Okay.
Go ahead, Ed. You can answer that.
So just quickly, I have a question about appeal. I heard that being bounced yesterday, that Chauvin definitely has a right to an appeal, and things were set up by his attorney, the defense, that made it possible for an appeal to take place.
Right. If I don't know if Derek Chauvin's attorney is going to handle his appeal. There are attorneys out there, and that's all they do is appellate work.
Okay.
Right. Believe it or not, most trial attorneys don't do appellate work because it's an entirely different type of work. Okay. And not every attorney that's good in the courtroom is necessarily going to be an expert in appellate matters.
Okay.
Right. So a lot of attorneys that you see doing appellate work, they prefer to just wade in paperwork and research and things like that, and monitor appellate cases, and look at the issues and read the record.
Do you think Chauvin will appeal?
Well, it's guaranteed that he'll appeal.
Absolutely.
No one. It's rare. It's rare for a defendant not to appeal, especially in criminal cases, especially when there's a considerable amount of time that they are subject to, or exposed to, or vulnerable to when it comes to the deprivation of their freedom and liberty. You can, this is a huge case. They will argue. There's a whole lot of things that they will argue on appeal. They'll claim that the judge erred by not granting their motion to change venue.
Right.
They'll raise that on appeal.
It was the second degree manslaughter charge, I think, is also at issue, I believe.
I think that was reinstated, but they'll appeal. They'll appeal
Sure,
because Maxine Waters scared the jury. They'll all kind of crazy appeals.
Yeah, they'll come up. Yeah, and keep in mind, Key, that there's always an argument. The legal system is designed to have competing arguments. There's always an argument on appeal. There's always an argument to be made. Whether or not the Court of Appeals grants it or the Supreme Court grants it, it's just a matter that remains to be seen, and you make your case and you let the fact finder decide.
Right.
But there's always an argument to be made. That's their job.
Great note to close on. Thank you to my all-star panel before I lose both of you all to the satellite here. Thank you. And you guys will be back because unfortunately we've got the Dante Wright case, we've got the Adam Toledo case in Chicago, and now we've got Micaiah Bryant in Columbus, Ohio, and then there was another shooting in Elizabeth City, North Carolina. There was an unarmed black man that was shot and killed. So I'm exhausted, man. I'm exhausted. I know you guys are exhausted. And I know he probably is like the mayor. She's exhausted dealing with mine. And P like, Keela, girl, I knew him before you did. Hey, listen, you guys are awesome. You are the best panel on any media platform. Thank you. Truly an all-star panel. Tequila Carson, attorney Paul Ellis. Listen, Paul, I want you to come back because I'm running out of time, but I want to get you to come back and talk about the August Wilson Foundation and the August Wilson House. And if people want to get more information real quick or just support the foundation, I know that the goal is to open the house. Are you on target to launch, to have the opening in 2021, or are you moving it back?
Well, we're trying. We just started major construction, so
okay. Well, good deal. Listen, let me jump in because I don't want to lose you. I know we're running out of time. Give people the website to where they can go get more information, and if they want to make a donation, if they want to support this wonderful foundation and support a true American icon, just give them the website information, Instagram or Twitter, where they can learn more, where they can donate.
Right. We have a strong social media presence. Our website is augustwilsonhouse.org. Everything that we do is posted on our Instagram and Facebook accounts. We're on Twitter as well. The August Wilson House is a national historic landmark designed to advance the legacy of August Wilson. When it opens, it's going to be a multidisciplinary art center designed to nurture and support emerging artists and restore his home to the period of significance. So it'll be heavy in arts education and arts programming. I'd be happy to come back on your show and tell your viewers all about it. It's a fascinating project and much, much needed in the Black arts community.
We're going to do that next week, P. All right? We're locking it in. Next week, you come in, and the whole show is going to be dedicated to telling the story of August Wilson, who is your uncle, by the way, your maternal uncle. And you nailed it, boy. Key, he's a bad man. I told you. I got the all-star panel, the best in the business, ladies and gentlemen. Keela Carson, Paul Ellis. Thank you all both. I love you guys. Thank you for joining me, okay? All right.
Thanks.
All right. Thanks for letting me be a part of your life as always. God bless each and every one of you. God, most of all, thank you for letting me do the Geno Show. Great panel. I love these guys. All right. So like, share, and subscribe. Please like, share, subscribe, and share all the episodes. You see, we bring the heat every day, every afternoon, every night. Check me out, Geno Jones Show on Instagram, Geno Jones on Twitter, Geno Jones Live, and Geno Jones on Facebook. I post these episodes, but you can always go back and binge watch on my YouTube channel. So please like, share, and subscribe to my channel. That's how you spell Geno Jones. And if you'd like to be a sponsor, I would be honored to have you as a sponsor. If you'd like to advertise here on my channel, if you are looking for the pitch man, I am the king of pitch, the king, not the king, the king of pitch men, pitch people for your product, your company, your good, or your service. Reach out to me, Geno Jones Show at Gmail, or you can leave me a message right here on my YouTube channel, Geno Jones Show, also at Gmail. All right. Thank you for watching, everybody. God bless each and every one of you. God, most of all, thank you for letting me do the Geno Jones Show. I love each and every one of you for watching. I really do. Please go back and binge watch last night's episode if you missed it, because it was straight fire, like tonight. And tomorrow will be another edition, Thursday edition, the Geno Jones Show Live. Shout out to Mr. Bruce Gage. He is the official wardrobe consultant for the Geno Jones Show, and Mr. Mark Hill Bailey, the official hairstylist, barber and hairstylist for the Geno Jones Show. Bruce Gage on Instagram, Gage, Bruce Gage, or flyballthestore.com. Kel B. Cuttin, KelBecuttin, Kel B. Cuttin on IG, on Instagram. Like I said, I love you. I really do. Mother, you know I always love you. You know I love you more than life itself, and I know you're watching, everybody. Thank you for watching. Please like, share, subscribe. Tell everybody you know. Share it on their pages. Tell them what they're missing. The most dynamic, the hottest, the funniest, just the most incredible, the baddest show on the planet in several galaxies, right here, the Geno Jones Show. Until tomorrow, Thursday, 6:30 p.m. Eastern, live. Once again, thank you for watching. Be blessed. See ya.
Subscribe and tune in to the next episode of the Geno Jones Show, exclusively right here on YouTube.